Hi guys, welcome back to my channel. So today in this video I would like to read an article entitled Maritime Liens in Ghana. So this is the fourth part of the video with the same title. Part 4. Critique: Absence of right of assignment and subrogation of maritime liens. Subrogation is one of the key principles of marine insurance law and necessary incident of the contract of indemnity. The rule of subrogation basically provides that on settlement of a loss, the indemnifier or insurer is entitled to step into the shoes of the debtor or assured. Having paid the assured for the loss, he is subrogated to all the rights and remedies of the assured for the loss in respect of the subject matter from the time of the casualty causing the loss. According to Lord Blackburn in Bowman v. Rodonachie, the doctrine of subrogation is rule of law and of equality. In his words, the general rule of law and its obvious justice is that where there is a contract of indemnity and a loss happens, anything which reduces or diminishes the amount which the indemnifier is bound to pay, and if the indemnifier has already paid it, then anything which diminishes the loss comes into the hand of the person to whom he has already paid the full. Indemnity is entitled to be recouped by having that amount back. The objective of subrogation is to prevent the assured from taking with both hands. That is to say, as assured is not permitted to recover more than his actual loss. He cannot take from the insurers and from the person who has caused the damage insured. This therefore permits the insurers to step into the shoes of the insured and to sue in his name any person through whose default or wrongdoing the loss may have occurred. However, the insurer is strictly confined to the right of the assured and cannot, by virtue of the doctrine of subrogation, acquire rights which the assured never possessed. For example, a right to sue himself when two of his own vessels collide with each other. In essence, the right of subrogation is ingrained in the common law and some extent in statutory law. In Ghana, for example, Sections 16 of the Contract Act 1960 provides that any guarantor or any person being liable together with another for any debt or legal duty who pays the debt or performs the duty shall be entitled to have assigned to him any security held by the creditor and to stand in the place of the director and use all remedies available to him in respect of the debt of duty. It is instructive to point out that although the Ghana Shipping Act 2003 makes some references to the concept of subrogation or assignment of some right, it is submitted that neither does these provisions apply to maritime liens nor do they answer the question whether the subrogation or assignment carries with it the simultaneous assignment or subrogation of the maritime lien, if it is a claim secured by a maritime lien. It is critical to state that the coming into force of the GSA seems to have cast some doubt or shadow over the principle of subrogation, as it particularly relates to the maritime liens in Ghana. This state of confusion stems from the fact that lawmakers is drafting the Ghana Shipping Act 2003 for whatever reason decided to exclude the corresponding provisions in the International Conventions on Lien and Mortgage 1993, which squarely addressed the problem. Article 6 of the Conventions provides that the assignment of or subrogation to a claim secured by a maritime lien set out in Section 66 of GSA entails the simultaneous assignment of or subrogation to such maritime lien. In this state, it is clear that the subrogations of a maritime claim concurrently involves the assignment of or the subrogations of such a maritime lien. This enables the insurers to step into the shoes of the assured and entitles him to the remedies that the latter may be entitled. However, with the exclusions of these provisions in the Ghana Shipping Act, it is attractive to argue that its exclusion is an indicator that Parliament does not intend insurer or indemnifiers of maritime claims to be subrogated to maritime liens in Ghana. This interpretation is consistent with a rudimentary rule of statutory interpretation that were from among a list of items or a number of provisions, all of which are capable of being included, but only some are included, thus not include are obviously exclude. This apparent quietude of a provision categorically affirming an assignee or subrogate's right a maritime lien appears in no cause to the uninitiated. However, with the benefit of the history of the subject, one soon realized that this confusion is real to industry players. The positions that Ghana seems to have taken in excluding the subrogation or assignment of maritime liens only plainly perpetuates an alleged common law prohibition on reluctance to assign or subrogate maritime liens, and the English case of the patron is often branded or heralded as authority for this proposition. In my considered view, even if the alleged common law prohibition against subrogation and assignment was an established common law rule, its usefulness is today discredited and out of touch with the current trend of judicial authority of maritime liens, and Ghana should not have followed it. In the patent, the plaintiff paid the crew's wages and made some disbursement at the request of the master of the ship. The plaintiff brought an action in Rome to exercise a lien on the vessel in respect of the payment the plaintiff has made held after reviewing some authorities that a third party who pays seamen's wages is not subrogated by the law to the maritime lien for the wages of the seamen. The Canadian courts have also long held that a debt for wages is assignable at common law, but the lien expires with the payment of the debt. The only exceptions to this rule is that seamen cannot assign their wages in anticipation of payment. Unfortunately, these decisions never gave any reason why a maritime lien could not be assigned or subrogated. So the time is up, and the article will be continued to read in the next video. So bye bye, and don't forget to watch the previews and the next video, and bye bye.